Hi, my name is Eric Willison, and this is Fatlock on Evidence. This is video number 2. In the previous video, our first evidentiary video, we talked about Evidence Rule 401. And 401 defined what was and what is not relevant evidence. Evidence Rule 402 says that if something is relevant under 401, then it comes in to evidence. It comes into the court, it becomes part of the record, and the person, whether it be the judge or the persons, if that be a jury, who are tasked with determining what happened in the case and deciding the case, may consider it in making their decision. It means it's admissible. 402, however, says if it's relevant, it comes in unless there's some other rule in the rules of evidence or in the laws or in the Constitution that says, no, we can't consider that sort of evidence. So, I think the Supreme Court of the United States, in the case of United States versus Evid back in 1984, 105, Supreme Court 465, said it best. I'm going to quote, because it sort of shows the interplay between 401 and 402 here. It says Rule 401 defines relevant evidence as evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would have been without the evidence. Rule 402 provides that all relevant evidence is admissible except as otherwise provided by the United States Constitution, by an act of Congress, or by applicable law. Now we're talking about the federal rules of evidence. State rules of evidence will also, of course, be controlled by your individual state's laws. The federal rules of evidence lay out a structure, and most state rules of evidence tend to follow the federal rules of evidence, if not word for word, pretty closely. But every state has a few little twerks and changes to what is federal evidence. But if you learn federal evidence, then you'll know probably about 90% of all of the state's evidentiary rules as well. Now, what this means is, so if the evidence you want to get in makes a difference in the case, then it's relevant. And relevant evidence comes in unless there's some other rule that prevents it from coming in. Now, there are two things that make evidence relevant. One is its probative nature, and number two, its materiality. Now, let's come up with an example for this. Let's say a guy named Frank is about to get on an airplane. He just finished a business trip. He's about to get on an airplane to go home. He's at the airport. And as he's walking down toward the gate where the terminal is, he looks over and he sees a guy in a pilot's uniform at the airport bar, slamming back some shot glasses of a brown liquid that sure looks like whiskey to him. Well, Frank figures, well, that's just some pilot who just got back from a big long flight. He wants to take a few drinks, and now he's going to maybe take a cab home. Doesn't think much of it. Then, as Frank's getting on the plane, lining up, he sees that same pilot walk past the line of passengers and go through the security doors. And then he kind of looks out through the window, and he sees the pilot appear on the tarp, the runway, and walk up the stairs and go onto the plane. This is the guy that was just slamming back the whiskeys. Okay? Now later on, as the plane is taking off, with Frank on it, whoever the pilot was forgot to extend the flaps, which allows the plane to fly and lift off the ground at slow speeds, because it increases the size of the wing, basically. This pilot, for whatever reason, forgot to extend the flaps, and because of that, the plane didn't clear the runway soon enough, and it maybe hit a tree or something and spun out of control, and a lot of people were hurt. So in a lawsuit over this plane crash, is Frank's observation of the pilot in the bar going to be relevant? Now, you and I are thinking, duh, of course it's relevant. You know, the pilot was drunk. Okay, but that's the way an amateur thinks about it. Now, you came to the right conclusion, okay? But when you're doing a law school exam or when you're in front of a judge, you don't just want to give a simple yes or no answer. Yes, that's relevant, move on. No, a law school question is not seeking a yes or no answer. It is an invitation from the law professor to the student to expand upon the student's knowledge and to answer the question in an orderly way, going through all the little analytical tumblers to come to the answer. And frankly, most of the answers, our witness's name is Frank, most of the answers that the law professor is looking for don't involve a yes or a no. The law professor does not really care whether you come down on one side of the question or the other. He or she just wants to see your process. And judges are the same way on tough questions, okay? So what happens is, this is a simple question, but let's say that we've got a much more tougher evidentiary question about something of a rule later on that's much higher and much more complex. If you start off simple and show how this starts off with whether it's relevant evidence or not, and the two aspects of relevancy, then you build on success after success after success until you get to that sort of vague, nebulous, spacey part. And now, because the judge was able to follow you all the way up to this point, and you are making good, perfect sense all the way up, now the judge is going to give you a little bit more trust when you come to state your position on the tricky bit, okay? Now, we're not going to have a tricky bit to this question. We're just going through this rather pedestrian exercise, but to show you what how the two aspects of probative and material apply to this. Now, so we got this example, and the fact that Frank looked over and saw the guy drinking what appeared to be alcohol is certainly probative of whether or not he's intoxicated. It doesn't absolutely prove it, but what it does, because maybe some guys have high tolerances, okay? But here's the thing. It makes the matter slightly more likely, or maybe if he was just drinking milk from a milk carton, then it would make maybe less likely that he was intoxicated. But probative is whether something is made less likely or more likely. Okay, so we've got the first elements, the first of the two elements of whether this is relevant or not. We're halfway there because Frank saw the pilot drinking what appeared to be whiskey and saw a bunch of it going down and at several shots. Okay, so we've got probative. We're 50% of the way there. Now we find out that, surprise, 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 Sergeant Carter, that there is a rule in federal aviation law that says that you are not supposed to fly a plane when you've had intoxicating liquors intoxicating substances, let's say, within the last 3 hours or whatever it is before the flight, okay? So now we see the fact that he was drinking within that time period, that is material. So now we're the rest of the way there. So now we've got the relevance, we've got the probity, the probative nature is the first element, and we've got the materiality is the second element. 50% plus 50%, 100%, we've got relevant evidence under Rule 401. And then when we turn to Rule 402, it says relevant evidence comes in unless there's a reason for it not to. Now, again, we're going to get into reasons for it not to. Now, let's change the facts just very, very slightly here. Everything is the same. Frank sees the guy drinking and so on and so forth. But then when the pilot gets on the plane, unbeknownst to Frank, the pilot isn't flying the plane. There's an extra fold-down seat in the cockpit, and he sits in that fold-down seat and straps himself in and goes for a snooze. And the reason he's flying up there is that it's a full plane. He'd much rather fly in the back where there's a full-size seat, but he's got to get back to Columbus or Seattle or Miami or wherever the plane's going, and he doesn't want to miss this plane because he's got a flight the next morning, and the next flight out's going to be not going to get him there in time. So he drank a few to make it so that it would be easier for him to sleep on the flight and in that uncomfortable chair. And so he gets in there, but he has nothing to do with flying the plane. He's just along for the ride. And then the plane crashes because the sober pilot was the one who forgot to put out the flaps as the plane was taking off. Now, we still have the probative nature of intoxication. We're still 50% of the way towards relevance because Frank looks over, he sees the guy dressed as a pilot, drinking, okay? But there's no materiality because there's no aviation law against a guy getting drunk and then getting into the cockpit and then sitting in the fold-down seat that doesn't control a thing and not making a disturbance and just falling asleep. There's no rule against that. Therefore, there's no materiality. So we don't get all the way to relevant evidence under Rule of Evidence 401. Therefore, because it's not relevant evidence under Rule 402, it does not come in. So, again, that's very, very simple, but this is how you pick up the extra points on a law school exam, is by going through even the simple stuff to show the professor that you understand that relevance isn't just something that's like, it kind of seems relevant to me. No, that's nebulous. That's how amateurs think. That's how non-lawyers think. You've got to show how you go through these little tumblers of probative nature and relevance. I'm sorry, probative nature and materiality that gets you to relevance. Then apply it through 402 because 402 says relevant evidence comes in unless we've got another rule of evidence somewhere else that says that can't come in. And the next video, we'll talk about Rule of Evidence 403, which is the very first rule of evidence that starts restricting what kind of relevant evidence can come in and what can't. Thanks for listening. I'm Fatlock on Evidence, and we'll see you later.